Welcome to Go Vote Omaha, presented by the League of Women Voters of Greater Omaha. I'm Geri Simon, a League member and your host. Each program we talk about important public policy issues, and we hope you'll discuss those same issues, and then at election time you'll be ready and willing to go vote. Our topic for this program is understanding impeachment. And to discuss that with us, we have as our guest Collin Mangrum. He's a professor of law, rules of evidence textbook author, and the Endowed Chair in Legal Ethics at the Creighton University School of Law. Welcome.
Thank you for having me.
Well, impeachment is much discussed in the news recently, but there does seem to be a lot of confusion about it. What it is, why it's used, and what the process is. So I'd like to start off with discussing what it means and where it's referenced in the Constitution. And we know that it's Article 2, Section 4 of the U.S. Constitution, so I'm just going to read it for it'll be up on the screen on a graphic for our viewers, the actual language, but I'll read it for those who may be listening on a podcast. And it says, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So one of the first questions you have is what is impeachment? It's the definition is not defined in that article.
No, but it's part of a long common law history, and it really comes from English common law history going back almost 1,000 years, just shortly after the Magna Carta. So it's more of a principle than a studied practice, but it's the concept of, the original rationale for it is that under English common law, the king could do no wrong, right? So the king provided the law and he could do no wrong, and that extended to his ministers. So as part of the Magna Carta and the process after that, the idea was if we're going to have a government of limited government, of separation of powers, then the people should have a way of removing the king's ministers for high crimes and misdemeanors. So the history goes back to the English common law, really 13th century.
Okay, and that's why we have it in our Constitution.
Exactly. I mean, the model of our Constitution is built around the English model, which they have the House of Commons and then the House of Lords, which would be the comparable of Congress, the House of Representatives and Senate.
Okay. So we know why it's there and the purpose. And one thing, you're the co-author of a 1974 Law Review article about impeachment after the resignation of Nixon, and written in that context.
It was actually written in the context, not afterwards. It was done
at the time.
At the time, and
okay.
it was supposed to be a procedural manual for the impeachment procedure.
Impeachment procedures, okay. And one of the things you talked about was that impeachment is fundamentally a political action process separate from a criminal action. So could you explain that for our viewers?
Sure. The whole idea of impeachment is to remove someone in office who's causing mischief, that's doing damage to the body politic. It's not aimed at punishing people for a crime. It's aimed at removing a person from office. And so because of that, there is an overlap in the procedure and some of the processes, but they're entirely different things.
Okay. And when you mentioned that it's not a punishment, it's also not intended as a procedure that is going to just remove someone who's unpopular or we don't like their policies. It's much more serious than that, is it not?
Well, it has some content. The provisions you just read has some content. So lawyers work from words when they talk about high crimes and misdemeanors. The idea has some historical foundation for that. But the essence, of course, is that where you have officers who are harming the body politic as compared to committing a robbery or something else that has nothing to do with the body politics, or some personal action that would be subject potentially to criminal action.
Okay. So it's really protecting the republic.
No question.
Okay. So let's talk about the specifics of the language. It's pretty clear it applies to the president and vice president. When we say all civil officers of the U.S., who does that mean?
That means all civil officers of the U.S.
Okay, so cabinet members.
Yeah, now cabinet members, we have a precedent for that. So we do, there's been one cabinet member that was impeached, gone through the impeachment process. But the language, all civil officers are subject to judicial interpretation. As a practical matter, it is most likely to be applied for people like cabinet members. And kind of the rationale behind that is where some people have to go through the Senate for confirmation. Those are the people most likely that would be subject to it. But there's no restriction on it. Civil officers is a broad term, and it's never really been interpreted to say that it doesn't apply way down the line, but it's unlikely to be applied to something other than fairly major political figures.
Okay. What about judges or members of the military?
Aha. Judges is an easy answer. The military, we've not done that before, and probably, unless it's a Joint Chiefs of Staff or something like that. The judges, the reason why the judges are an obvious answer is because we've done it a whole bunch of times. And the reason for that is part of the constitutional history in the United States as we got into the Revolution was the fact of the concept of the independence of the judiciary, very important constitutional principle for separation of powers, and basically the structure of Article 3. And we, more than even England, wanted to protect the autonomy of the judges. And so we wanted to, during the Revolution, part of the problem there is the courts went to the merchant courts, the admiralty courts, where there was no right to jury trial, and the judges were all appointed by the crown. And the colonists hated the admiralty courts for that very reason. And so part of what we put into our Constitution is that judges are appointed for life. So that, unlike the English common law where they could be removed by the crown, our judges cannot be removed by the president. They only can be impeached. They serve a life tenure, and even their salaries can't be impacted. And so because of that, the judges have created the most precedent because there's been 15 judges who have been, bills of impeachments have been filed against them. And that's because they cannot be removed by anyone other than the impeachment process.
Okay. So let's look at some of the other language there. There's treason, bribery, and then the kind of catch-all, high crimes and misdemeanors. So would you explain what those terms mean?
Well, they all have historical criminal context, but they're not confined by criminal standards because this is a political process. The language are intentionally general and somewhat vague because they want to keep it general so they can do it whenever they feel like it's appropriate. The concept behind them, though, is simple. I mean, is that anytime the people in office are doing something that would harm the republic, so they're focusing on crimes that relate to a political office, not crimes that are more personal in nature. And so the experiences we have with the actual historical precedents like Nixon deal with decisions that are made that could harm the republic in general as compared to personal actions.
Okay. And so other terms that we hear talked about, I think a lot are discussed when you talk about impeachment, is the term obstruction of justice and collusion. Are those legal terms? They
have specific legal connotation, yes.
Okay.
And obstruction of justice is a closer concept to the concept that we're talking about for impeachment. Because the principle behind obstruction of justice is that the president would have some control, potentially have some control over judges and over the processes and subpoena power. And if the president starts to interfere with, and that came out clearly in the Clinton impeachment process, because that's where we get some of our precedent. So Clinton clearly tried to obstruct justice. And so he was, what that meant, he's trying to suborn perjury, he's trying to get some of his secretary and other people, Monica Lewinsky, and other people to lie about the factual events in a civil action. The underlying civil action was a Paula Jones action. But there's no question but that Clinton perjured himself, and then he attempted to convince other people to get him out of that box. And that was the obstruction of justice claims in that case.
Okay. And the Nixon case, certainly obstruction of justice.
No question. That's even easier because now we're talking about the Watergate offices and getting espionage in there. Now we're talking about the political process and attempting to subvert the election itself. And so the Nixon case is the easier case than between the two of them.
Okay. Well, talk a little bit about the actual process of impeachment. Could you explain to our viewers and listeners how does it work?
Yeah, and you know, this is again being developed in process because we haven't done it often enough to develop it. But we know some general guidelines. Number one, the person who would preside over the impeachment trial would be the Chief Judge of the Supreme Court. That's the trial in front of the Senate. Okay. Prior to that, the House has an investigatory stage and process, and they're going to have, by tradition, the House Judiciary Committee appoints some people. They do investigation. They have some people who function the equivalent of a prosecutor in a criminal case. They do the fact-finding investigation, and they bring the bill to the House, and the House vote only requires a majority vote to extend to the impeachment trial itself, which is exactly what happened in the Clinton case. You know, there was sufficient facts to establish a bill of impeachment, then it went to the Senate. Okay. So there's a trial. The trial's in front of the Senate. The investigation and the bill of impeachment is in front of the House. Okay.
So in the Clinton case, he was impeached, but
right.
It went to trial in the Senate, and he was not convicted.
That's true.
Okay.
Now, the conviction has to be by a 2/3 vote as compared to a majority vote in the House.
Okay. So it's a pretty stringent.
It's a very stringent, and it should be because of separation of powers. The whole
right.
idea is if people elected a president with separation of powers, is we're only going to undo that process if we're convinced.
Right. Is it a speedy process, or should it be?
Is it and should it be? It's not a speedy process, or it can be a speedy process depending on the facts of the case. It's not likely to be a speedy process because, number one, if you include in the process the fact-finding investigation, then you want to have serious investigation to be able to determine whether or not you have something to work from. And in the most recent investigation, so you have investigations ongoing, and you have a special committee or someone who has subpoena power goes out and does some fact-finding. That may take quite a while, and you want that to be thorough. Mm-hmm. That part of it would be the initial fact-finding to determine whether or not there's sufficient information to even go forward at all with a hearing on the impeachment. The impeachment process itself, the hearing at the House, has not typically been very long. And it can be by witness, or it can be by affidavit, or a testimony separate from that. The rules have not been established. Okay. And one of the other aspects of the Clinton hearing is that the question is who controls the procedure and even the rules of evidence. And the argument was, well, the Supreme Court justice who's in charge should be doing that, and the Senate said, I know. So it's a political process controlled by both the House and the Senate, not by even the Chief Justice. Okay.
But there may be some legal aspects which the court would handle, and that kind of brings us to, we
right.
were talking earlier about what about executive privilege and keeping any documents out of the investigatory part of the impeachment process.
Yes, the rules of evidence, formal rules of evidence that we normally use in trials are generally not followed, or at least they haven't been in the past been followed, but the executive privilege is a very important, in fact, that's one of the most important things I think that came out of the Nixon case, because that whole case turned on whether or not Nixon could keep the tapes protected from investigation through the impeachment process. And the U.S. Supreme Court, unanimous opinion in the Nixon case, said no. And what they said in that case, which has to be understood in context, is that any privilege usually goes through a judge. And they have an in-camera hearing to see whether or not the scope of the privilege fits the facts of the case and whether they should pursue the privilege itself. So and what the case in Nixon said, the Supreme Court decides that, not the president. Okay. So if there's an issue of executive privilege, it would go to the Supreme Court, not to the impeachment body, but to the U.S. Supreme Court, and they would make an in-camera determination as to whether or not executive privilege applies. Okay. And if it does not, they would order the president to turn over the documents, which is exactly what happened in Nixon.
So for our viewers and listeners, in-camera means that only the judges are privy and are able to look at those documents, and they determine if anyone else can.
And that's exactly what happens on privileged cases throughout all the courts in the country, is they have hearings to determine whether or not the privilege fits the facts.
Okay. So we have this process in the Congress, in the House, and in the Senate. Is it important that the public be convinced of an official's guilt if he or she's tried in the Senate and found guilty at trial? Why would that be important?
As a practical matter, the answer is yes. As a legal matter, the answer would be no. But of course, this is a political trial, and the people involved in it are all politicians. And so the politicians who are in their office because they are politically astute, they have to understand the mood of the government and the people and to decide whether or not the people are with them. Because if the people aren't with them, they're not likely to get a conviction. And if they're not likely to get a conviction, the impeachment process itself can backfire on the people who pursue it. There's an old maxim, you know, if you strike at a king, you must kill him. And I think that principle is applicable here is if you don't think you have it, it's foolish to go forward.
Okay. So in terms of the Clinton case, if we look at that, might that be one of the reasons that he was not convicted in the Senate trial? Because not everyone was truly convinced, and certainly the public, there was a split view, if you believe what's written in the press about it, that there was a split view of whether people thought he really should be impeached.
I think that's true. The political will was not with them. Also, of course, because it's a political process in a case like Clinton, you're not going to get any Democratic votes in favor of conviction because it's a political process. And so when you look at your party lines, you can start to count noses. Now there won't be unanimous normally, but the lines are going to be pretty tight on these type of things because it is a political process. If you think that the public's not with you and you don't have the votes, then by bringing the bill of impeachment and stirring up a distraction from what people should be doing, it may be the people who actually start the process but can't finish it are going to suffer more than the person that's being investigated.
Okay. So if, in the process, if someone's impeached and then found guilty at trial, what happens then to the office?
If they're impeached by the Senate and they're convicted by a 2/3 vote, which requires a 2/3 vote, they're out of office.
Okay.
Now, there is a second step that we haven't gone through, but the second step is the Senate can choose to prevent them from ever holding office again. That's
Okay.
part of the process,
Okay.
potential process. But the impeachment process is not designed to punish them in a criminal context. It's only designed to remove them from office. And then you have the separate question as to whether or not they're prosecuted criminally after they're out of office.
Right.
The president cannot be prosecuted while he's in office.
Right. But there could be criminal prosecution when an office holder leaves office or is removed then.
That's the constitutional principle, yes.
Okay.
And that's why the two separate processes are handled procedurally differently and have a different purpose.
Okay. So we've only a handful of times that this has been done in terms of the president. You mentioned we've already talked Nixon, Clinton, and Andrew Johnson's the other
Right.
case. Can you just talk briefly about that one?
Yeah, Andrew Johnson, very interesting case. I mean, because it really got steeped into the Civil War and who's in charge of different things. So Johnson came in, tried to remove a cabinet member, or did remove the Secretary of War. And the question is whether he had authority to or need to get approval of the Senate. And it was a fight back and forth about whether it was appropriate to get him to do that because it was approved by the Senate. Interestingly enough, the U.S. Supreme Court, in a later case, Myers, really ended up siding with Johnson. But that impeachment process didn't. They got impeached, but no conviction. So he stayed in office.
One vote to stay
Right.
in office on the
That's
trial,
right.
right?
Yeah, so it was a close vote.
Very close.
And I think the proper result and the approach that the president took there, asserting, look, it's my executive officers. If I want them in or if I want to take them out, I have the authority to do that, even if they've been confirmed by the Senate. That has since been ratified by the U.S. Supreme Court case in a case called Myers.
Okay.
But he was right constitutionally.
Okay. There's been one instance where a cabinet member has been impeached,
Right.
and that's the Belknap case.
Right.
And it's also unusual because he was impeached after he resigned. So talk about that a little bit.
Yeah, and the two things interesting about that is it is interesting because he was the only cabinet member, so every time we have precedent, we look at it and build from it. And the allegations there that he was corrupt, he was taking money, earning money from military posts when they had basically anytime you have a fort, you had providers, trader providers, who's going to pay, who's going to provide the materials for the fort, and he was taking money, which is the allegation. In that particular case, he resigned, and then now the Senate's looking at what do we do now, and they decided to go ahead with impeachment. After that happened, however, the Senate adopted as a matter of rule, if they resign, we're not going to go forward with the impeachment in the future.
Okay.
But that's the Senate rule,
Okay.
which also can be changed.
So the next question being, could Nixon have been impeached after he resigned? They had already made the determination that they weren't going to go there?
Well, and I think, and I would say it's not likely to happen, but when I wrote on this and talked about this in the past, one of the interesting things about a president as compared to other people is that if a president resigns, he's still been a former president, and he would be entitled to a certain significant benefits after he's removed from office, after he leaves office. And one of the suggestions why impeachment would still make sense potentially is to remove him from office and therefore have an argument that he ought not to receive all the benefits that he would receive otherwise, the retirement type benefits and the other benefits that a president receives after they're out of office. Okay. But that would be the only reason why you'd want to go through it, is because there's a consequence separate from the removal of office. And also separately, the other part of that is whether or not you have a ruling that he can never hold office again.
Again, right, okay. We'll talk a little bit about alternatives to impeachment. And you've written about that a little bit, so tell our viewers more about that. What can we do that's just short of impeachment? Well,
he could be not elected next time he runs for office, for one thing. You could have censure. They could come up and issue different type of House resolutions censuring people. And because it's a political process, most of the answers are political, not legal. Now, the one thing he cannot do is prosecute while he's in office.
Right.
But that's everything else is on the table.
Is on the table, okay. Well, one of the other things that you talked about was certainly the press has a role to play in this. And what about, I thought one interesting thing you talked about was a White House staff, speaking about the president, White House staff that are committed to preserving the republic and the rule of law. So how does that fit into not impeaching a president?
Well, and this is, for example, in the Clinton case, one of the people that the argument was supporting perjury was the secretary.
Right.
So you have some interesting things where you have people who have their own personal integrity, and you have their boss and someone they have a close relationship with. And Clinton apparently tried to convince his secretary to misrepresent whether he had spent time with Monica Lewinsky and those types of things. Now and this is also part of the obstruction of justice claim, now he's not only taking a position himself, but he's trying to suborn perjury in third parties, including his own staff.
Right.
And that's where it becomes more problematic, and that's why the obstruction of justice becomes more of a central theme for impeachment processes, because you're trying to cheat the process. Whenever you're attacking the process, the governmental process, it sounds more like it's an impeachable offense.
Okay. And that was true really in Nixon too, wasn't it, with the famous 18-minute gap in the recordings
exactly.
there? So, okay.
Anytime you're trying to suborn perjury, you're trying to destroy documents, they call it spoliation. Anytime you're trying to avoid the courts actually finding out what's going on, or in this case, Congress or the Senate, from finding out what's going on, that hits at the heart of the rule of law. And back to the Magna Carta, the whole process we've been working with constitutionally from the 13th century or before was the idea that no one should be above the law. And so we should have a process in place that will allow us to remove even the highest people in offices in a legal way. And even though this is a political process, because it is very similar to a legal process, then we borrow a lot from the criminal process and apply it to the political process. But ultimately, it's a political process, and both the Senate and the House and the people, if they're not on board, it's not likely to happen. Right.
But ultimately, the process there to protect the integrity of the republic.
That's the point. That's the point. And if they commit a crime, and they're still subject to the criminal action post office.
Okay. All right. One thing, we just have a couple minutes left here, and one thing I wanted you to talk a little bit about is about censure. It's only been used once against a president, against Jackson. So talk about what is censure and how can that be an effective process or action that the Congress could take?
Well, part of it is it's almost like in a criminal trial or civil trial, you may have a contempt for the judge or something. This is a statement, look, we may not have an impeachable offense, but we want to take a position on this issue. We want to go on record, make a point that what you're doing, whether it's impeachable or not, what you're doing is inappropriate and against the Republic. So a censure could be basically a statement that this may be short of high crimes and misdemeanors. We don't think we can necessarily get the votes because of the constituency that we have, the arrangement of the House or the Senate. We still think we want to make a statement about this.
So
in the
strong disapproval.
That would be the concept.
And shame comes into it, I think, in terms
of course. You know, and you can see the officers who, almost all these people, including Nixon, openly weeping when things happened, when they were, stained their history and knowledge. It's not just their office and not just their going out of office, but forevermore. They're in office in part for their own recognition of being someone significant and powerful. They don't want to go down as someone who is the first or one of the only people ever to be censured by, we're talking about, this will be the second precedent.
Yes.
So if you're talking about it's not often it doesn't happen very often, but you don't, if you can bring a cannon, you don't want to do it to kill a mouse.
Okay, right. Well, we will leave it there, and I thank you so much for being here to discuss this important subject. I think our viewers and listeners have learned a lot more about impeachment.
Thank you.
So for the League of Women Voters, I'm Geri Simon, reminding you to inform yourself about the issues, and at election time, go vote, Omaha.